Earlier, I talked about how we need an original will. What about a case where we don't have that, but we do have a photocopy of the will?
Yeah, so that is a problem because there are two ways in the law to revoke a will. One is you write a new will that says, I hereby revoke all prior wills, which is what we always do. Every time we write a will for a client, we say that right in the will. The other way to revoke a will is to destroy it, rip it up, light it on fire, whatever. But if all you can come forward with is a photocopy, it raises the suspicion that this decedent destroyed their will and there really is no will. So you do have to go through a procedure where you submit documentation, testimony saying that there is a lost will. There's a lost will because we can't find the original. All we can find is photocopy. And you've got to have, basically witness testimony to support that. Like, I know my uncle had a will. He showed it to me 3 days before he died. I don't know where it is, but this is the copy of it that he showed me in the folder with the original. And, whatever you have to do to say this is actually his original will. And as we're going to talk about probably in a future episode, the family members have an opportunity to object and say, no, that's not, he destroyed that will. That's not his will. And that's why you can't find it anymore. Or something, whatever they want to say. So that's a challenge. And so if you're listening out there and you have an estate plan, it's very important to keep track of that original will. Don't lose it. Don't stick it in a safe that nobody knows about. It's very important to keep track of that original will.